1295-2022, Honorable Michael Enyong versus INEC and PDP.
Okay, my lord, we are not in this matter. Then we're in 1249.
Yes. Oh, I see. Maybe yours is next.
Okay, my
I'm in
lord.
this matter, my lord.
Yes, representation. Can you introduce yourself?
Yes, my lord. I am, most respectfully, my lord, I am Anthony Onyeri for the first defendant, my lord.
Yes.
My appearance for the first defendant.
Yes, I heard that.
Most
Any
grateful,
other count?
With profound humility, my lord, I am NJA2 for the plaintiff.
Your name again?
NJA2. NJA2.
Eto.
N-A2. ETUK, my lord.
Any more? Judgment. The plaintiff initiated this action by an originating summons dated 1st August 2022 and filed same date. The plaintiff, Honorable Michael Enyong, took the determination of 3 questions and sought 8 reliefs. The summons is issued against 2 defendants, namely 1, the Independent National Electoral Commission, INEC, first defendant, and People's Democratic Party, PDP, second defendant. The plaintiff subscribed the following questions for determination. Questions for determination. 1, whether having regard to the combined provisions of sections 29 sub 1, 2, and 3, 32 sub 1, 84 sub 1, and 8 of the Electoral Act 2022, sections 25 sub 1 and 2 of the second defendant's constitution, the preamble to the constitution of the second defendant, as well as the order of this honorable court, Honorable Justice Achegu Iguatu, met on the 18th day of May 2022. The plaintiff is not the authentic and validly nominated gubernatorial candidate of the second defendant in Akwa Ibom State for the forthcoming 2023 general elections. 2, whether having regard to the combined provisions of sections 29(1), 2, and 3, 32(1), 84(1), and 8 of the Electoral Act 2022, sections 25(1) and 2 of the second defendant's constitution, the preamble to the constitution of the second defendant, as well as the order of this honorable court, Honorable Justice Achegu Iguatu, met on the 18th day of May 2022. The second defendant ought not to submit the name of the plaintiff, the first defendant, as its authentic and validly nominated gubernatorial candidate in Akwa Ibom State for the forthcoming 2023 gubernatorial elections. 3, whether having regard to the combined provisions of section 29(1), 2, and 3 of the second defendant's constitution, the preamble to the constitution of the second defendant, as well as the order of this honorable court, Honorable Justice Achegu Iguatu, met on the 18th day of May 2022. The first defendant ought not to issue nomination form to the plaintiff, recognize and deal with him as the authentic and validly nominated gubernatorial candidate of the second defendant in Akwa Ibom State for the forthcoming 2023 general elections. Relief sought. If the answers to the above questions are in the affirmative, the plaintiff seeks the following reliefs. Thus, 1, a declaration that in view of the combined provisions of sections 29(1), 2, and 3, 32(1), 84(1), and 8 of the Electoral Act 2022, sections 25(1) and 2 of the second defendant's constitution, the preamble to the constitution of the second defendant, as well as the order of this Honorable Court Quorum, Honorable Justice Ategu Egwatu, met on the 18th day of May 2022. The plaintiff is the authentic and validly nominated gubernatorial candidate of the second defendant in Akwa Ibom State for the forthcoming 2023 general elections. 2, a declaration that in view of the combined provisions of sections 29(1) and 2 and 3, 32(1), 84(1), and 8 of the Electoral Act 2022, sections 25 sub 1 and 2 of the second defendant's constitution, the preamble to the constitution of the second defendant, as well as the order of this Honorable Court Quorum,
Okay, but the video is on.
Honorable Justice Ategu Egwatu, met on the 18th day of May 2022. The second defendant ought to submit the name of the plaintiff to the first defendant as is authentic and validly nominated gubernatorial candidate in Akwa Ibom State for the forthcoming 2023 general elections. 3, a declaration that in view of the combined provisions of sections 29(1), 2, and 3, 32(1), 84(1), and 8 of the Electoral Act 2022, sections 25 sub 1 and 2 of the second defendant's constitution, the preamble to the constitution of the second defendant, as well as the order of this Honorable Court, Honorable Justice Ategu Egwatu, met on the 18th day of May 2022. The first defendant ought to issue nomination form to the plaintiff, recognize and deal with him as the authentic and validly nominated gubernatorial candidate of the second defendant in Akwa Ibom State for the forthcoming 2023 general elections. 5, an order directing the second defendant to forthwith submit the name of the plaintiff to the second defendant as the authentic and validly nominated gubernatorial candidate of the second defendant in Akwa Ibom State for the forthcoming 2023 general elections. 6, an order directing the first defendant to forthwith issue nomination form to the plaintiff, accept the plaintiff's name, recognize and deal with him as the authentic and validly nominated gubernatorial candidate of the second defendant in Akwa Ibom State for the forthcoming 2023 general elections. 7, an order of injunction restraining the second defendant from submitting any name other than the name of the plaintiff to the first defendant as the authentic and validly nominated gubernatorial candidate of the second defendant in Akwa Ibom State for the forthcoming 2023 general elections. 8, an order of injunction restraining the first defendant from accepting, acting on, according recognition to, or in any way or manner dealing with, or any person other than the plaintiff as the authentic and validly nominated gubernatorial candidate of the second defendant in Akwa Ibom State for the forthcoming 2023 general elections. And 9, for such or further orders as this Honorable Court may deem fit to make in the circumstances of this case. In support of the originating summons is an affidavit of 31 paragraphs with 11 exhibits. The affidavit is deposed to by the plaintiff himself. Summary of facts. The plaintiff stated that he's a politician and a bona fide registered and card-carrying member of the second defendant in Okuwan, Ward 10, Uyo local government area of Akwa Ibom State, that with a view to being nominated as the gubernatorial candidate of the second defendant in Akwa Ibom State for the forthcoming 2023 general elections, he purchased expression of interest and nomination forms of the second defendant to contest the second defendant's gubernatorial primary election for Akwa Ibom State. He duly completed and submitted the aforesaid expression of interest and nomination forms to the second defendant, after which he was successfully screened and cleared to participate in and contest the second defendant's gubernatorial primary election for Akwa Ibom State, in consequence of which the second defendant issued him a certificate of clearance to participate in the said gubernatorial primary election. That after the second defendant screening exercise, as aforestated, the second defendant scheduled its gubernatorial primary election for Akwa Ibom State to hold on the 25th day of May, 2023. And that prior to that date, some aggrieved members of the second defendant vied suit number FSC ABJCS 606 2022, retired Honorable Friday Ewok and others versus Independent National Electoral Commission and others, approached this honorable court and sought, among others, for an order restraining the second defendant from utilizing its ad hoc delegates to conduct its gubernatorial primary election in Akwa Ibom State in view of the illegalities with which the election of the party's ad hoc delegates are fraught. And that further to the above, on the 18th day of May 2022, this honorable court, Quorum Honorable Justice Obiora Atiego Eguatu, in the above reference suit number FSC ABJCS 606 2022, retired Honorable Friday Ewok and others versus Independent National Electoral Commission and others, made an order directing parties in this suit, including the defendants herein, to maintain status quo ante bellum, thereby preventing the second defendant from utilizing its list of ad hoc delegates to conduct its gubernatorial primary election in Akwa Ibom State, pending the determination of the substantive suit in suit number FSC ABJ CS 606 2022. As a result of the court order joining the 3rd to 331st defendants in this matter, the number of defendants in the suit increased from 2 to 331. And in light of the order, the lawful option available to the second defendant to adopt in the conduct of its gubernatorial primary election in Akwa Ibom State, as scheduled to hold on the 25th May 2022, was to conduct the state primary election using direct primary election procedure, consensus or indirect primary election procedure with the use of its list of statutory delegates. The deponent stated that the Electoral Act and the second defendant's constitution provide for the use of statutory delegates in the conduct of the second defendant's primary elections, and also one of the key functions of the second defendant's statutory delegates is the election/nomination of the second defendant's gubernatorial candidate for the purpose of a general election, and that all statutory delegates of the second defendant were democratically elected. In fact, that the second defendant used statutory delegates for its 2022 Osun State gubernatorial primary elections, which took place after the coming into force of the Electoral Act 2022, as well as its primary elections in Imo State, including its gubernatorial primary election in the state. And that consistent with the foregoing, the second defendant utilized its statutory delegates to conduct its gubernatorial primary election for Akwa Ibom State on the 25th day of May 2022, wherein the plaintiff duly participated and contested as an aspirant, wherein the following aspirants participated and scored the following votes as announced by the officers of the second defendant and monitored by the first defendant. 1, Etim Anekon Akau, 0 votes. 2, Senator Basi Albert, 50 votes. 3, Chief James Anema, 0 votes. 4, Honorable Michael Enyon, 2,448 votes. 5, Mr. Umo Eno, 239 votes. 6, Mr. Onofiok Luke, 34 votes. 7, Mr. Akan Okon, 5 votes. 8, Honorable Ide Owo Odion, 0 votes. Total accredited votes is 2,776. The deponent stated that the aforesaid Akwa Ibom State gubernatorial primary election of the second defendant held on 25th May 2022 was conducted/ratified by the National Executive Committee of the second defendant and with the knowledge of the National Secretariat of the second defendant. And at the conclusion of the aforesaid second defendant's gubernatorial primary election, the deponent emerged the winner, having been nominated by a majority of lawful votes cast thereof and satisfied the requirements of the law. And also by its timetable and schedule of activities for political party primaries, the last day mandatorily given by the first defendant for all political parties to conduct and conclude their primary elections was the 9th day of June 2022. That since the plaintiff was lawfully and validly nominated as the second defendant's Akwa Ibom State gubernatorial candidate for the forthcoming 2023 general elections, as aforestated, the second defendant has failed, refused, and/or neglected to submit his name to the first defendant as its Akwa Ibom State gubernatorial candidate. The plaintiff stated that he became aware that the second defendant did not submit his name to the first defendant as aforestated on the 22nd day of July 2022, when he discovered that the first defendant did not publish his name as a duly nominated gubernatorial candidate of the first defendant in Akwa Ibom State, and that unless directed by an order of this honorable court, the second defendant will persist in its refusal to submit the plaintiff's name to the first defendant as its Akwa Ibom State gubernatorial candidate for the forthcoming 2023 general elections. And again, unless directed by an order of this honorable court, the first defendant will continue in its refusal to accord him recognition, issue him nomination form, or publish his name as the second defendant's Akwa Ibom State gubernatorial candidate for the forthcoming 2023 general elections, and that granting the relief sought in this suit will enhance internal democracy in the second defendant and accord with the dictates of the rule of law. Also accompanying the affidavit are 11 exhibits marked as exhibits A to K. Exhibit A is a copy of plaintiff's membership card of the second defendant. Exhibit B, C, and D are expression of interest and nomination forms of the second defendant together with the purchase receipt to contest the second defendant's gubernatorial primary election for Akwa Ibom State. Exhibit E is a certified true copy of the originating summons in suit number FSC ABJCS 606, 2022, retired Honorable Friday Ewok and others versus Independent National Electoral Commission and others. Exhibit F is a copy of the said certificate of clearance. Exhibit G is a certified true copy of the said order of this honorable court. Exhibit I are copies of results of the said primary election. Exhibit K are copies of results. Exhibit K is a certified true copy of the defendant's timetable and schedule of activities. Counsel to the plaintiff, Peter Nwatu Esquire, in his written address formulated 3 issues, which questions issues for determination he argued together as they have overlapping purposes. The plaintiff seeks the resolution of the following questions. 1, whether having regard to the combined provisions of sections 29(1), 2, and 3, 32(1), 84(1), and 8 of the Electoral Act 2022, sections 25(1) and 2 of the second defendant's constitution, the preamble to the constitution of the second defendants, as well as the order of this Honorable Court, Honorable Justice Ategu Iguatu, met on the 18th day of May 2022, the plaintiff is not the authentic and validly nominated gubernatorial candidate of the second defendant in Akwa Ibom State for the forthcoming 2023 general elections. 2, whether having regard to the combined provisions of sections 29(1), 2, and 3, 32(1), and 8 of the Electoral Act 2022, sections 25(1) and 2 of the second defendant's constitution, the preamble to the constitution of the second defendant, as well as the order of this Honorable Court, Honorable Justice Ategu Iguatu, met on the 18th day of May 2022, the second defendant ought not to submit the name of the plaintiff to the first defendant as its authentic and validly nominated gubernatorial candidate in Akwa Ibom State for the forthcoming 2023 general elections. 3, having regard to the combined provisions of sections 29(1), 2, and 3, 32(1), 84(1), and 8 of the Electoral Act 2022, sections 25(1) and 2 of second defendant's constitution, the preamble to the constitution of the second defendant, as well as the order of this Honorable Court, Honorable Justice Ategu Iguatu, met on the 18th day of May 2022, the first defendant ought not issue nomination form to the plaintiff, recognize and deal with him as the authentic and validly nominated gubernatorial candidate of the second defendant in Akwa Ibom State for the forthcoming 2023 general elections. Learned Counsel submitted that the law is right, that where there's a right, there's a remedy, will be just remedial, and that it is the duty of the court to construe a statutory provision in such a manner as not to defeat the obvious ends which the statute was designed to serve. Thus, the court has always been enjoined to opt for that interpretation which will make for the smooth working of the system for which the statute was enacted. Learned Counsel urged the court to give effect to the provisions of sections 29(1), 2, and 3, 32(1), 84(1), and 8 of the Electoral Act 2022, with the requirements of the law that where a statute has made provisions for steps to be taken or procedure to be followed in doing an act, no step other than those prescribed must be followed. Therefore, where a political party conducts a primary election and a winner emerges, such a political party is duty bound by section 84 sub 5C of the Electoral Act 2022 to submit the name of the winner as its candidate to the second defendant. Where the political party decides to do otherwise, the winner of the primary election can approach this court for its intervention. Counsel argued that political parties are creations of the statutes, are creations of the Constitution and statutes. Therefore, the affairs of registered political parties in Nigeria must act within the confines of the 1999 Constitution of the Federal Republic of Nigeria, the Electoral Act, their registered constitution, and relevant electoral guidelines. Learned Counsel argued further that in line with the above position of the law, the question that calls for answer at this point is whether the plaintiff is not the authentic and validly nominated gubernatorial candidate of the second defendant who ought to be issued with nomination form, recognized and deal with as the authentic and validly nominated gubernatorial candidate of the second defendant in Akwa Ibom State for the forthcoming 2023 general elections, that the response to this poser is most answered in the negative for reasons provided. Learned Counsel contended that as part of the process leading to primary elections for political parties, the Electoral Act provides for the mode of primary elections for political parties under Section 84 of the 84 of the Electoral Act 2022 to include the direct primary, indirect primary, and consensus. And that the second defendant herein opted for the option of indirect primary as provided for in the state section 84 of the Act, and it is in the spirit of section 84 sub 4, that's section 25 sub 1 and 2 of the second defendant's constitution was enacted and same applied for by the second defendant in its primary election, which led to the emergence of the plaintiff as the candidate of the second defendant. Learned Counsel contended further that this honorable court is bound to give effect to the sacrosanct provisions of sections 29(1), 2, and 3, 32(1) of the Electoral Act 2022, and also order the defendants to accord recognition and deal with the plaintiff as the second defendant's Akwa Ibom State gubernatorial candidate for the forthcoming 2023 general elections. Council concluded by submitting that the foregoing clearly reveals that there's merit in the case of the plaintiff, as abundant evidence reveals that there's merit in the case of the plaintiff, as abundant evidence has been presented to demonstrate that the plaintiff, having validly emerged as the Akwa Ibom State gubernatorial candidate for the second defendant, he is entitled to be issued the nomination form in that regard and recognized by the first defendant accordingly. And in consequence, this honorable court is urged to resolve the issues/questions submitted for determination in favor of the plaintiff and grant the relief sought in the originating summons. On being served with the originating summons on the defendants, the first defendant filed an affidavit of facts deposed to by one Ayuba Jacobs on 21st November 2022, accompanied by written address of same date. Counsel to the defendant, Anthony Onyeri, Esquire, in his written address in support of the affidavit of facts, adopted the three issues for determination as formulated by the plaintiff. Learned Counsel submitted that the central issue in this matter deals with nomination of the second defendant's candidate in respect of Akwa Ibom State governorship election 2023, that the first defendant does not intend to respond to issues raised by the plaintiff, as the nature of the case being on nomination of candidates for election is such that the first defendant shall abide by whatever decision the court arrives at. And that this position is consistent with the admonition of the Supreme Court to the first defendant on similar cases, particularly in Hope Ozodinma versus Osita Izunaso number 2, 2011, 17 NWLR, where the Supreme Court Fabi JSC stated, I quote, "With all the above, the third respondent, Independent National Electoral Commission, said it remains neutral in this episode, but still felt that the appeal should be dismissed. Independent National Electoral Commission, a body which is an umpire, should be seen to be really neutral at all times. In reality, a sympathizer should not weep more than the bereaved, only heard cries at burials engaged in such a mundane ploy," end of quote. Counsel submitted further that the first defendant is guided by the admonition of the Supreme Court and does not intend to take any position in this case. It shall be bound by whatever order the court makes. The plaintiff, in his reply while adumbrating in court, submitted that the affidavit of facts filed by the first defendant does not constitute a defense as required by the rules of this honorable court. At best, the first defendant is sitting on the fence and not having controverted the affidavit of the plaintiff in originating summons, urge the court to be guided by the decisions in the cases of Ogwejo versus Ogwejo 2006, 3 NWLR, and RMFC versus AG River State and another 2021 LPLR Court of Appeal, in arriving at the conclusion that none of the defendants has filed any process to controvert the process in the originating summons, and none of them has defended this suit, and asked the court to hold so and grant the reliefs in this suit. Meanwhile, the second defendant never put in an appearance despite the proof of service of being served with the originating summons and all other processes. Now, this honorable court will utilize the 3 issues articulated by the counsel to the plaintiff and also adopted by counsel to the defendant, which are earlier read about twice. So I'll not read it again. This is a suit commenced by an originating summons filed on 1st August 2022. The plaintiff, having formulated 3 questions for determination, sought 8 reliefs before this honorable court, as contained on pages 1 to 4 of the originating summons. This honorable court, in resolving the above issues, which have overlapping purposes, will determine all the 3 questions together, as argued by plaintiff's counsel. The facts of this case, as succinctly put by the plaintiff, revolves around the authentic candidate of the second defendant for Akwa Ibom governorship election. The plaintiff filed this suit seeking, amongst others, an order directing the second defendant to forthwith submit the name of the plaintiff to the first defendant as the authentic and validly nominated governorship candidate of the second defendant for Akwa Ibom State governorship election slated for 2023. Meanwhile, none of the defendants has filed any process to controvert the process in the originating summons, and none of them has defended this suit. Although the first defendant has filed what he termed as an affidavit of facts, to which the plaintiff counsel derided the affidavit of facts filed by the first defendant by stating that the affidavit of facts does not constitute a defense as required by the rules of this court, and that at best, the first defendant is sitting on the fence. The contention by plaintiff's counsel is uncalled for, as the first defendant is a neutral party and an arbiter. The first defendant cannot afford to join the fray, and that was why the learned counsel to the first defendant submitted that the central issue in this matter deals with nomination of the second defendant's candidate in respect of Akwa Ibom State governorship election 2023, and stated that the nature of the case being on nomination of candidate for election is such that the defendant shall abide by whatever decision the court arrives at. While the plaintiff contended that the crux of the plaintiff's case does not border on a primary election dispute, rather a post-primary dispute of failure to issue nomination form to the plaintiff and failure of the first defendant to publish his name as the second defendant's gubernatorial candidate for Akwa Ibom State, having won the gubernatorial primary election of the second defendant in Akwa Ibom State. This honorable court has observed that the first defendant, being the Independent National Electoral Commission, a body which is an umpire, having taken the above stated stand, has shown that it is neutral, which is how it ought to be and should be seen to be at all times. The first defendant should not be seen as a sympathizer who weeps more than the bereaved, as only heard cries at burials engaged in such a mundane ploy, as succinctly put by the learned lord of the Supreme Court, Justice Fabi JSC, as he then was, in the case of Hope Ozodinma versus Osita Izunaso Supra. The position taken by the first defendant is consistent with the admonition by the Supreme Court to the first defendant on similar cases. In the case of Attorney General of the Federation and others versus Alhaji Atiku Abubakar and others, the Supreme Court stated, I quote, "The Independent National Electoral Commission, INEC, by its statutory existence, is an independent body with constitutional powers to conduct elections in Nigeria. It must not only be an umpire, it must be seen in the eyes of reasonable men to be an impartial umpire in the conduct of an election. INEC must never, by acts of omission or commission, place itself in a position where imputation of partiality in favor of one party against another will be leveled against it. Neutrality must be the watchword of the body, must always remain fair and focused," end of quote. The first defendant has no business in this case to file a defense controverting the affidavit of the plaintiff's originating summons. Rather, the first defendant, as a neutral party and arbiter, heeded the above admonition of the Supreme Court by not responding to the issues raised by the plaintiff. Therefore, it is clear from the above authority, the first defendant did not act ultra vires or in clear contravention of the law, which means that the contention of plaintiff counsel that the first defendant is sitting on the fence is in tandem with the law, I so hold. All authorities and persons have a duty to obey the law of the land and act in accordance with the express provision of saying. To do otherwise will enthrone arbitrariness, that the activities of a political party cannot be operated arbitrarily or at the whims or caprices of select individuals, no matter how highly placed. Political parties are creations of the Constitution and statutes. Therefore, the affairs of registered political parties in Nigeria must run in conformity and in obedience to the law creating them. The litmus test for the validity well known of actions of a political party is that any such actions must be consistent with the Nigerian Constitution, the Electoral Act, the Constitution of the party, and its guidelines. In support of the above position of the law, the Supreme Court in APC versus Marafa 2020, 6 NWLR held that, I quote, "Political parties must not act arbitrarily, they must act within the confines of the constitutions and electoral guidelines and in accordance with the provisions of the Electoral Act." Similarly, in Emeka versus Okadibo, 2012, 18 NWLR, the Apex Court held inter alia thus, "The courts will never allow a political party to act arbitrarily or as it likes. A political party must always obey its own constitution," end of quote. This honorable court, by the above holding, reiterates that the second defendant is not imbued with any virus to act contrary to the outcome of the primary election. I'm fortified by this line of thinking by the holding of the Supreme Court in the case of Olugbemi versus Lawrence, 2017 LPELR SC, which is on all fours with this case. The first respondent, plaintiff, was declared winner of his party's primary election, but the party forwarded the name of the appellant. The court unanimously dismissing the appeal held that a political party does not have the power to act contrary to the outcome of its primary elections, except in very limited exceptional circumstances, and that those exceptional circumstances are as provided by Section 31 and 33 of the Electoral Act 2022. Now, in the instant case, the issues have nothing to do with notice of withdrawal of candidature as stipulated in Section 31 and 33 supra. When all of these are put together, and in the absence of any counter affidavit filed in contradiction of the affidavit in support of the originating summons, This honorable court is satisfied by the preponderance of evidence and based on balance of probabilities applying the Supreme Court's decision in Mogaji and others versus Odofin and others, 1978 for Supreme Court, 91 at 93. The plaintiff is the validly and lawfully elected candidate of the first defendant for the Akwa Ibom State Gubernatorial Primary Election conducted on the 25th day of May, 2022, in compliance with Section 84 sub 8 of the Electoral Act 2022 and Sections 25, 1 and 2 of the Constitution of the first defendant. This is the holding of this honorable court. This court, being not just a court of law alone, but of justice, in arriving at the conclusion, is guided by the decisions of the appellate court in the cases of Ogo Ejiofor versus Ogo Ejiofor 2006, Supra, RMFC versus AG River State and another 2021, in that none of the defendants has filed any process to controvert the process in the originating summons, and none of them have defended this suit. The plaintiff is contending that his rights have been infringed by a second defendant, and he is before the court. He is before this honorable court to ventilate, saying the Supreme Court held by Augie JSC in Napoleon Orianzi versus Attorney General, River State, 2017, 6 NWLR, I quote, "If a plaintiff has a right, he must of necessity have the means to vindicate it, and the remedy if he is injured in the enjoyment or exercise of it. There cannot be a right without a remedy. For want of right and want of remedy are reciprocal. The maxim ubi jus ibi remedium is the Latin rendition of the principle. The maxim is so fundamental to the administration of justice that where there is no remedy provided by common law or statutes, the courts have been urged to create one. The court cannot therefore be deterred by the novelty of an action. In other words, the law is an equal dispenser of justice and leaves no one without a remedy for his right. Wherever there's a wrong, there must be a remedy to redress that wrong. Justice must not only be done, but must be seen to be done. In the instant case, the appellant has a right, he was deprived of enjoying same, and there must be a remedy." End of quote. In the final analysis, this honorable court holds that the plaintiff has successfully proved his case on the preponderance of evidence. Consequently, the plaintiff is hereby declared the validly nominated gubernatorial candidate of the second defendant, having emerged winner of the conducted primary election in Akwa Ibom State for the forthcoming 2023 general elections held on 25th day of May 2022. In the same vein, any other governorship primary election held after the valid election of 25th day of May 2022, that election having no basis in law is hereby declared null, void, and of no effect together with its outcome. The second defendant is hereby ordered to submit and present the name and details of the plaintiff to the first defendant as its rightful candidate. The first defendant is to accord the plaintiff recognition, issue him with nomination form, or publish his name as the second defendant's Akwa Ibom State gubernatorial candidate for the forthcoming 2023 general elections. This shall be the judgment of this court.
Thank you.
My Lord, on behalf of the plaintiff, we are very grateful. And we commend your lordship for the time and industry put in the delivery of these judgments. We are very grateful, my lord.
Welcome. call in the second, just a minute. Let me print out the second judgment.
Okay, at this point.
Okay, I can call in the next case.
President of the Senate National Assembly, 3, Independent National Electoral Commission, INEC.
I'm so sorry, my lord. We can't hear him, my lord.
Can you, let me give you the microphone.
Most gracious lordship.
Suit number FSC/ABJ/CS/2049/2022 between People's Democratic Party (PDP) versus 1 Senator Albert Basi Akpan, 2 President of the Senate National Assembly, 3 Independent National Electoral Commission (INEC).
The presentation.
As the court pleases, may it please your lordship. My name is Paul Mbioma. My appearance is for the plaintiff.
Yes.
May it please your lordship.
My lord, appearing with me,
Emmanuel Ekong.
appearing with me, my lord, is my learned friend. Is my learned friend Lemia Wai. Lemia is Lemea.
Yes.
Wayih. I'm most grateful to your lordship.
Lemia Wayih.
Wayih. W-A-Y-I. Yes, my lord. W-A-Y-I-H.
Okay.
Yes, my lord.
Yes.
For the plaintiff, my lord.
Okay. Yes.
May it please your lordship. Emmanuel Ekong. Appearing with me is my learned friend, I.S. Otuk, and E.M. Uyo. Appearance is for the first defendant.
Yes.
With profound humility to this honorable court, K.O. Lawal is my name. I hold the brief of K.T. Sulaiman. Sulaiman is spelled S-U-L-A-I-M-A-N. Lyman. For the second defendant.
Any more representation virtually?
My Lord, it appears that's all for now, my Lord.
Thank you. Judgment. The plaintiff initiated this action by an originating summons dated the 28th July 2022 and filed same date. The plaintiff, People's Democratic Party, PDP, seek the determination of 2 questions and sought 6 reliefs. The summons is issued against 3 defendants, namely Senator Albert Bassey Akpan, first defendant, President of the Senate National Assembly, second defendant, and the Independent National Electoral Commission, INEC, third defendant. The plaintiff subscribed the following questions for determination. 1, whether having regard to section 65(2)(b) of the Constitution of the Federal Republic of Nigeria, 1999, the first defendant, being a person whose election on 23rd February 2019 to the office of Senator representing Akwa Ibom Northeast Senatorial District, otherwise known as Uyo Senatorial District, was sponsored by the plaintiff, is no longer qualified to retain his seat in the Senate, having resigned his membership of the plaintiff before the expiration of the period for which he was elected. 2, whether having regard to section 65(2)(b) of the Constitution of the Federal Republic of Nigeria, 1999, the first defendant being a person whose election on 23rd February 2019 to the office of Senator representing Akwa Ibom North East Senatorial District, otherwise known as Uyo Senatorial District, was sponsored by the plaintiff, is not liable to vacate his seat in the Senate, having resigned his membership of the plaintiff and become a member of Young Progressive Party before the expiration of the period for which he was elected. Relief sought. If the answers to the above questions are in the affirmative, the plaintiff seeks the following reliefs. 1, a declaration that by virtue of section 65(2)(b) of the Constitution of the Federal Republic of Nigeria, 1999, the first defendant being a person whose election on 23rd February 2019 to the office of Senator representing Akwa Ibom Northeast Senatorial District, otherwise known as Uyo Senatorial District, was sponsored by the plaintiff, is no longer qualified to retain his seat in the Senate, having resigned his membership of the plaintiff. 2, a declaration that by virtue of section 68(1)(g) of the Constitution of the Federal Republic of Nigeria, 1999, the first defendant, being a person whose election on 23rd February 2019 to the office of Senator representing Akwa Ibom Northeast Senatorial District, otherwise known as Uyo Senatorial District, was sponsored by the plaintiff. It's liable to vacate his seat in the Senate, having resigned his membership of the plaintiff and become a member of the Young Progressive Party before the expiration of the period for which he was elected. 3, a declaration that the seat of the Senator representing Akwa Ibom Northeast Senatorial District, otherwise known as Uyo Senatorial District, in the Senate has become vacant. 4, an order that the third defendant shall conduct a by-election to fill the vacant seat of the Senator representing Akwa Ibom State, Akwa Ibom Northeast Senatorial District, otherwise known as Uyo Senatorial District, in the Senate for the unexpired term of the first defendant, not later than 30 days after the order of this court. 5, an order that the first defendant shall refund to the Senate of the National Assembly all monies, allowances, or other financial and material benefits paid, given, or yielded to him after July 15th, 2022. 6, an order of injunction restraining the first defendant from claiming to be or parading himself as the senator representing Akwa Ibom Northeast Senatorial District, otherwise known as Uyo Senatorial District in the Senate. 7, cost of the suit as may be determined by the court. The plaintiff's originating summons is dated 28 July 2022 and filed same date. There are 2 questions for determination of this court and six reliefs. The originating summons is supported by an 26 paragraph affidavit deposed to by one Harrison Echo, attached 3 exhibits marked Exhibit PDP-1, PDP-2, and PDP-3 respectively. Also filed is a written address in support of originating summons. The plaintiff filed a further 16 paragraph affidavit deposed to by same Harrison Echo in support of originating summons dated 4th November 2022 and contains 2 exhibits marked as PDP-4 and PDP-5. There is a written address attached to further affidavit dated 31st October, filed 4th November 2022. In response to second defendant, the plaintiff filed a further affidavit deposed to by the same deponent Harrison Echo attached to the further affidavit. Okay, exhibits 4 and 5. I think I'm repeating myself. The first defendant filed a notice of preliminary objection dated 13th and 14th, 13th October, filed 14th October. Also, first defendant counter affidavit filed on the 17th and deemed filed 18th October 2022. There's also the first defendant better and further affidavit in support of preliminary objection deemed duly filed 29th November 2022. The second defendant filed a counter affidavit on 4th September 2022 along with a written address dated 31st August and filed 4th September 2022 and a further affidavit dated 4th November 2022. Summary of facts. The deponent one, Harrison Echo, is a member and the secretary of the plaintiff, PDP, Akwa Ibom State Chapter, with the consent and authority of the plaintiff, make the depositions contained therein and safe where otherwise expressly stated. The facts deposed to in this affidavit are within the deponent's personal knowledge. Other facts not within his personal knowledge have been obtained by him from records kept by the plaintiff, all of which facts he verily believed to be true and correct to the base of his knowledge, information, and belief, in that the first defendant was a member of the plaintiff in Ibiono, Ibom, Eastern Ward 1 of Ibiono, Ibom local government area in Akwa Ibom State. The deponent stated that whilst a member of the plaintiff, the first defendant enjoyed the benefits of membership of the plaintiff, including sponsorship by the plaintiff for election into political offices, to which the first defendant was sponsored by the plaintiff for election to the office of senator representing Akwa Ibom Northeast Senatorial District, otherwise called Uyo Senatorial District of Akwa Ibom State, and was consequently elected on 28 March 2015. And after concluding his tenure as a member of the Senate from 2015-2019, the first defendant vied and was re-elected to the same office on the platform of the plaintiff on 23rd February 2019. And having been re-elected to the office of the senator representing Akwa Ibom Northeast Senatorial District on the 23rd February 2019, his term of office should ordinarily have expired in June 2023. And in the Senate, the first defendant currently serves as the chairman, Senate Committee on Upstream Petroleum Resources. The deponent stated further that by a letter dated July 15, 2022, the first defendant wrote to the plaintiff ward chairman for Ibiono, Ibom Eastern Ward 1, Ibiono, Ibom Local Government Area, Akwa Ibom State, Arekamawil, Nyong Asoku, to inform the plaintiff of his resignation from the party. The first defendant subsequently joined the Young Progressives Party, picked his membership card number 3887, and made a public declaration of his membership of that party on Monday, 18th July 2022. That this was widely reported in the national newspaper. On 20th July 2022, the first defendant notified the Senate and the second defendant at plenary that his resignation from the plaintiff took effect from 15th July 2022, which fact was widely reported in a national newspaper. The deponent stated further that there has not been any division in the plaintiff political party, whether before or after the resignation of the first defendant and joinder of the Young Progressive Party, and that by virtue of his resignation from the membership of the plaintiff, the first defendant ceased to be qualified to retain his seat as a member of the Senate with effect from 15th July 2022, thereby liable to vacate his seat in the Senate because his election was sponsored by the plaintiff, but he has now joined another political party, that is the Young Progressives Party, and that having left the plaintiff to join the membership of another political party, the first defendant should have vacated his seat in the Senate, but has refused to do so, and that the first defendant has continued to take the benefits of his election into the Senate on the platform of the plaintiff and continued to parade himself as a member of the Senate and still continue to draw remuneration for that office. That the plaintiff, being dissatisfied, the deponent deposed that this honorable court has the inherent power to make orders to restrain the first defendant who has resigned his membership of the plaintiff on whose platform he was elected as a member of the Senate of the National Assembly from continuing to act or parade himself as a member of the Senate representing Uyo Senatorial District in the National Assembly, and that the Akwa Ibom North Eastern Senatorial District, otherwise called Uyo Senatorial District, seat in the Senate having become vacant, the third defendant has a duty to conduct election into that office in accordance with the provisions of the Constitution. In support of the originating summons is an affidavit of 26 paragraphs deposed to by the deponent. And next to same are 3 exhibits marked PDP 1 to PDP 3. Exhibit PDP 1 is a copy of the first defendant's letter of resignation of his membership of the plaintiff dated 15th July 2022, which letter was received by the party on the same date. Exhibit PDP 2 is a copy of the national newspaper of Monday, 18th July 2022, with the news report that the first defendant has joined the Young Progressive Party, picked his membership card number 3887, and made a public declaration of his membership of that party. Exhibit PDP 3 is a copy of the newspaper report that the first defendant notified the Senate and the second defendant at plenary that his resignation from the plaintiff took effect from 15th July 2022. On this side, with the originating summons on the defendants, the first defendant joined issues with the plaintiff by filing a notice of preliminary objection accompanied with a written address urging the court for an order striking out or dismissing this suit in its entirety for want of jurisdiction on the following grounds. One, the plaintiff's suit as presently constituted is not justiciable as it is predicated on matters bordering on the internal or administrative management / control and disciplinary decision and or policies of the Senate of the National Assembly. Two, the plaintiff respondent lacks the requisite local standard to institute this action. Three, the plaintiff's suit as presently constituted before this honorable court has not disclosed a reasonable course of action for the honorable court to consider and determine same. Four, the relief sought either in favor of or against a non-party to the suit, and accordingly, the court has no jurisdiction to adjudicate against or in favor of a non-party. In support of this application is an affidavit of 20 paragraphs deposed to by the first defendant applicant himself, by virtue of which position he deposed that he's conversant with the facts of this case and having read the plaintiff's originating summons together with the affidavit in support, that the applicant's entire grounds as contained in the originating summons is founded on issues which strike at the root of the internal affairs of the Senate of the National Assembly, which the Honorable Court does not have the jurisdiction to adjudicate on, as the 1999 Constitution of the Federal Republic of Nigeria provides for 3 arms of government with distinct powers and duties, that each arm of government is independent of each other in the performance of their constitutional duty, and none of the arms of government is enabled by the Constitution to take over the administrative function of the other, let alone regulate the conduct of the internal affairs of the other arms. The deponent stated that the plaintiff's grounds, as can be gleaned from the originating summons as well as in the affidavit in support thereof, is predicated on the provisions of section 68(1) of the Constitution. That section 68(2) of the Constitution provides for procedures to be followed in giving effect to the provisions of section 68(1)(g) of the Constitution, and 68(2) of the Constitution donates power to the Senate President to the exclusion of any other person, entity, or even the other arms of government to give effect to the provisions of section 68(1) of the Constitution. And that the Constitution mandates the Senate President or members of the Senate to first present evidence satisfactorily to the House that any of the provisions of section 68(1) of the Constitution has become applicable, and the decision of the House based on the evidence presented to it by the Senate President or members of the Senate is final on the matter. The deponent stated further that the provision of section 68(2) of the Constitution leaves no room for judicial interference, that the plaintiff has no local standard to maintain an action against the first defendant with respect to internal or administrative management control and or disciplinary decisions or policies of the Senate of the National Assembly. And the plaintiff has no legal right to protect in this suit over and above the first defendant or even over other defendants, in that the plaintiff has not alleged or disclosed in his originating summons that any of his rights have been breached by the action of the defendant in this case. The deponent stated that the plaintiff is not one of the persons stated in section 68(2) of the Constitution to give effect to the provision of section 68(1) of the Constitution or present evidence satisfactory to the House that any of the provisions has become applicable in respect of the first defendant. Therefore, the plaintiff cannot meddle into the internal affairs of Senate of the National Assembly, that it will be in the interest of justice if this application is granted, as the plaintiff will not be prejudiced if this suit is struck out or dismissed. Counsel to the first defendant, Solomon E. Umo, SAN, in his written address in support of the notice of preliminary objection formulated 4 issues for determination. 1, whether having regard to the peculiar facts and circumstances of this case, the questions presented by the plaintiff for the court's determination and the claims and or reliefs upon which those questions are predicated, which essentially can only be activated by the internal or administrative management control and disciplinary decisions or policies of the Senate of the National Assembly, are justiciable. And if the answer to the above proposal is in the negative, whether this honorable court has the requisite jurisdiction to entertain the claim of the plaintiff. 2, whether having regard to the peculiar facts and circumstances of this case, the plaintiff has the requisite local standard to institute this action against the defendant, having regards to the fact that the prerogative to activate the court's jurisdiction as regards Section 68 sub 1G of the Constitution of the Federal Republic of Nigeria, 1999, can only be activated by the second defendant or any member of the Senate by providing evidence satisfactorily to the House concerned that any of the provisions of Section 68 sub 1G have become applicable. 3, whether having regards to the peculiar facts and circumstances of this case, the plaintiff has disclosed any reasonable course of action for the honorable court to determine. And 4, whether having regard to the peculiar facts and circumstances of this case, this honorable court has the requisite jurisdiction to grant the relief sought by the plaintiff, since same will either inure to the benefit of or against a non-party to this suit. Leonard SAN, in his written address in support of the notice of preliminary objection, submitted that the courts, as custodians of the supreme law and the fundamental laws of the land, are to jealously guard the supremacy of the Constitution in its interpretation, and asked the court to resolve all issues formulated and argued by the first defendant, objector applicant, in his favor and against the plaintiff, sustain the objection and strike out and or dismiss this suit for the following reasons. Counsel listed about 6 reasons. A, B, C, D, E, that this action is frivolous and instituted in bad faith to vex, irritate, and annoy the first defendant in particular and other defendants herein. The plaintiff counter affidavit in opposition to first defendant notice of preliminary objection through the same deponent, one Harrison Ekpo, a member and secretary of the plaintiff, PDP Akwa Ibom State chapter, deposed that he read the first defendant's notice of preliminary objection dated 13th October 2022, including the 20-paragraph affidavit in support of the objection deposed to by the first defendant on 14th October 2022 against the plaintiff's originating summons, and verily believe that the facts contained in the affidavits are false, and that the second defendant's counter affidavit was not deposed to by the second defendant himself, but a counsel in the law firm retained by the second defendant. The plaintiff counsel, Paul Beoma Esquire, in his written address, adopted the 4 issues as formulated by the first defendant in their notice of preliminary objection in responding to the submission. The plaintiff, in opposition to first defendant's notice of preliminary objection, replied that based on the submissions and case law, plaintiff urges this honorable court to dismiss the first defendant's notice of preliminary objection because 1, the questions and reliefs in the plaintiff's originating summons are justiciable. 2, the court has jurisdiction to entertain the plaintiff's action as constituted. 3, the plaintiff has demonstrated that it has local standard to initiate and maintain the instant action. 4, the plaintiff's originating summons discloses a reasonable course of action that can be determined by this court. 5, section 681G and 682 of the 1999 Constitution is actionable in court and does not relate to matters within the internal affairs of the Senate of the National Assembly. 6, non-joinder of the Senate of the National Assembly cannot vitiate the action of the plaintiff since it is not a necessary party in determining whether the seat of the first defendant has become vacant. And 7, the objection of the first defendant lacks merit. The first defendant filed a further and better affidavit to the first defendant's preliminary objection filed on the 14th October 2022. And in response to the plaintiff's counter affidavit in opposition to the preliminary objection deposed to by one Inyobong Utu, a lawyer by profession, and the senior legislative aide to the first defendant, by which position he stated his conversant with the facts of this case and that paragraph 5 of the plaintiff's counter affidavit in opposition to the defendant's preliminary objection is untrue and incorrect. The first defendant's written address in support of further and better affidavits reply of points of law in response to the plaintiff's counter affidavit and written address dated 31st October 2022, but filed 4th November 2022 in opposition to the first defendant's preliminary objection filed on the 14th day of October, urged the court to sustain the first defendant's objector's preliminary objection and strike out or dismiss the claim of the plaintiff. Also, the first defendant's counter affidavit in opposition to the plaintiff's affidavit in support of the originating summons dated and filed was deposed to by the same person that deposed to the affidavit in support of notice of preliminary objection, one Inyobong Utuk, a lawyer by profession and the senior legislative aide to the first defendant in this case. Now, reading through the first defendant counter affidavit in opposition to originating summons of the plaintiff, this honorable court realizes that the affidavit and written address, as well as the submissions and arguments in the notice of preliminary objection, are the same. And already having reproduced them earlier in this judgment, there's no need to rehash them the same again. Meanwhile, the plaintiff haven't filed a further affidavit in response to the defendants, to first defendant's counter affidavit. The deponent stated, contrary to paragraph 10 and 11 of the first defendant's counter affidavit, the Constitution does not state that it is the second defendant or a member of the Senate of the National Assembly that must first present satisfactory to the House that the provision of section 68(1) of the Constitution has become applicable to the first defendant before there can be any action as in the present suit. In support of the further affidavits, in response to the first defendant's counter affidavit are two exhibits marked PDP-4 and PDP-5. Exhibit PDP-4 is a copy of the acknowledged letter of the first defendant, dated 18th July 2022, with reference number SEN/OBA/P/VOL. Volume 3/31 to the second defendant, intimating the second defendant of his resignation from the plaintiff and defection to Young Progressive Party, the receipt of which was acknowledged by the office of the second defendant on July 20th, 2022. Exhibit PDP-5 are copies of images in relation to the defection of the first defendant from the plaintiff to Young Progressive Party, YPP. Obtained from his Twitter account handle, was publicized by the first defendant to his about 11,000 followers on Twitter, social media application via the first defendant's official account handle at Senator OBA alongside other information, or Senator Ova alongside other information about his defection from the plaintiff to YPP. Before delving into the issues in contention in this case, it is important to first dispose with the issue of jurisdiction and for seamless consideration of the issue of jurisdiction and competence to entertain this suit gleaned from the grounds of notice of preliminary objection of the first defendant objector and the counter affidavits filed by both the first and second defendants in opposition to the originating summons. It is expedient and appropriate to take all together for brevity and to save judicial time of court, and also by virtue of the court rules and the pre-election practice direction 2022, all processes, the originating summons, the affidavit in support, the preliminary objection of the defendant and their respective counter affidavit against the originating summons are required to be considered together, being the current position of the law, in that all processes of all parties must be considered to determine whether a court of law has jurisdiction and or there is a cause of action or not in a suit. This honorable court haven't stated the processes of the plaintiff and the first defendant. The court will now proceed to determine the preliminary objection relied upon by the objectors. A close scrutiny of the grounds of objection suggests clearly that the notice of preliminary objection is founded on issues of law for this court to strike out or dismiss this suit for lack of jurisdiction premised on the grounds stated, wherein the first defendant raised the issues of non-justiciability, lack of local standi, no reasonable cause of action, and non-party to the suit. Counsel to the first defendant, Solomon E. Umo, SAN, in his written address in support of the preliminary objection, formulated 4 issues, which I earlier on read out. Now, starting with the first issue, one, with being whether, having regard to the peculiar facts and circumstances of this case, the questions presented by the plaintiff for the cause determination and the claims and or reliefs upon which these questions are predicated, which essentially can be activated by the internal, which essentially can only be activated by the internal or administrative management / control and disciplinary decisions or policies of the Senate of the National Assembly are justiciable? And if the answer to the above poser is in the negative, whether this honorable court has the requisite jurisdiction to entertain the claim of the plaintiff. Nana Silk, to the first defendant, counsel to the first defendant submitted in his argument by arguing copiously in paragraphs 1.7 to 4.0 of the written address in support of the first defendant's notice of preliminary objection, that the questions formulated and relief sought by the plaintiff are not justiciable since they deal with internal affairs of the Senate and National Assembly, and which can only be activated by the Senate. The plaintiff counsel, on the other hand, submits that whilst it does not dispute the constitutional provisions for the separation of the powers and functions of the arms of government, the cases cited by the first defendant do not apply in the present suit, and that it is tried that a case is an authority for the facts and law that they decide, and that what the first defendant is doing in essence is inviting this court to read into the Constitution what is not contained therein, when he argued that by Section 68(2) of the 1999 Constitution, the determination whether Section 68 sub 1G is applicable is an internal affair of the National Assembly, and urged the court to rest the surreptitious invitation of the first defendant to add to the provisions of Section 68 sub 2 of the 1999 Constitution, which is not contained in it. Going by the above submissions of learned counsel, is this honorable court clothed with the jurisdiction to entertain the questions and reliefs sought in the plaintiff's originating summons? It is tried that in determining jurisdiction, the court consider the claim and relief sought by the plaintiff, see Honora versus Kaduna Refining and Petrochemical Company Limited, and Abdul Hamid versus Aka and another. Now, I've hearing again reproduce the question posed by the plaintiff in its originating summons, which haven't read it, I will not read it again. The plaintiff grouse is predicated on the provisions of Section 68 sub 1G of the 1999 Constitution of the Federal Republic of Nigeria, which provides thus, 68(1), a member of the Senate or of the House of Representatives shall vacate his seat in the House of which he is a member if G, being a person whose election to the House was sponsored by one political party, he becomes a member of any other political party before the expiration of the period for which that House was elected, provided that his membership of the latter political party is not as a result of a division in the political party of which he was previously a member, or a merger of two or more political parties or factions by one of which he was previously sponsored. The same section goes to provide further in subsection 2, persons involved in the procedure persons involved and the procedures to be followed in giving effect to the provisions of subsection 1 above as follows. 68 sub 2, the President of the Senate or the Speaker of the House of Representatives, as the case may be, shall give effect to the subsection 1 of this section. So, however, that the President of the Senate or the Speaker of the House of Representatives or a member shall first present evidence satisfactory to the House concerned that any of the provisions of that subsection has become applicable in respect of that matter. This Honorable Court, having laid out the submissions of the first defendant counsel with that of the plaintiff counsel, particularly the questions and relief sought in the originating summons, which are construed from provisions of Section 652B and 681G of the 1999 Constitution in resolving this issue, that this issue is not justiciable, we refer to the dictum of Ugochukwu Anthony Ogaku, JCA, in the case of INEC versus DPP and another 2015 LPLR, to which the learned Lord held such cases to be justiciable and without recourse to the second defendant, notwithstanding the provision of Section 68 sub 2 of the Constitution. In INEC versus DPP Supra, where the appellant had filed an objection similar to the one filed by the first defendant in this case, where it also challenged the competence of the suit, including arguments that the first defendant ought to have first given effect to Section 1091G by the provision of Section 109 sub 2 of the Constitution before recourse may be made to the court. The appellate court held that such an interpretation cannot be the intendment of the framers of the Constitution. And if it were the case, the Constitution would have made express provision to that effect. The relevant portion of the dictum is reproduced here below. Section 109 sub 1G and 109 sub 2 of the 1999 Constitution provides as follows. A member, 1091, a member of a House of Assembly shall vacate his seat if G, being a person whose election to the House of Assembly was sponsored by a political party, he becomes a member of another political party before the expiration of the period for which that House was elected, provided that his membership of the latter political party is not as a result of a division in the political party for which he was previously a member, or of a merger of two or more political parties. By one of which he was previously sponsored. 2, the Speaker of the House of Assembly shall give effect to subsection 1 of this section. So, however, that the Speaker or a member shall first present evidence satisfactory to the House that any of the provisions of that subsection has become applicable in respect of that member. The present question is whether there's anything in the above stipulation which prevents an action from being commenced until after the Speaker has acted pursuant to Section 109 sub 2. I hate to think that that represents the legal position. As ingenious and imaginative as the contention of the appellant may seem, it does not represent the legal position. If the framers of the Constitution had intended that no action shall be instituted until after the Speaker has acted, pursuant to Section 109 sub 2, it would have been expressly stated. The Constitution is a living document, it is organic. In construing it under undue regard must not be made to mere technical rules, otherwise the objects of its provisions as well as the intentions of the framers of the Constitution will be frustrated. The courts in interpreting the Constitution have to resort to the cardinal rules of interpretation so as to ascertain the intention of the lawmakers from the words used by them, and to ensure that the object and true intent of the Constitution and statutes are preserved. Now, Section 109, sub 1 and 2 of the Constitution, which is in pari materia with section 68 sub 1 and 2 of the Constitution, in view of the decision of the Court of Appeal in INEC versus DPP cited above, where it was held contrary to the submissions of the Linus Silk counsel to the first defendant. Therefore, the contention of first defendant that the questions formulated and relief sought in the plaintiff's originating summons are not justiciable because they are predicated on and can only be activated by the internal or administrative management / control and disciplinary decisions or policies of the Senate of the National Assembly is not correct, as that contention has been laid to rest by the above holding of the in INEC versus DPP Supra. Consequently, this Honorable Court finds and holds that this Honorable Court is vested with the requisite jurisdiction to entertain, consider, and determine the questions and reliefs as presented by the plaintiff, being justiciable, which clothes this Honorable Court with the necessary virus to entertain the plaintiff's action, so constituted, as constituted. Now, going on to the second issue, which reads, whether having regard to the peculiar facts and circumstances of this case, the plaintiff has the requisite locus standi to institute this action against the first defendant, having regard to the fact that the prerogative to activate the court's jurisdiction as regards section 68 sub 1G of the Constitution of the Federal Republic of Nigeria can only be activated by the second defendant or any member of the Senate by providing evidence satisfactory to the House concerned that any of the provisions of section 68 sub 1G have become applicable. The first defendant counsel submitted on this issue that in the instant case, neither has the plaintiff demonstrated to this Honorable Court that he indeed has a legal right to protect in this suit, nor is he one of the persons listed in the Constitution to give effect to the provision of section 68(1) of the Constitution or present evidence satisfactory to the court, to the House, that any of the provisions of section 68 sub 1 A to H of the Constitution has become applicable in respect of the first defendant. And that section 68 sub 2 of the 1999 Constitution does not confer locus standi on the plaintiff to give effect to the provisions of section 68(1) G of the Constitution, and particularly as it has failed from the affidavit evidence in support of the originating summons to show that the questions sought to be determined by this Honorable Court relate to its civil rights and obligations. Neither has it shown that it is in imminent danger of any conduct of the defendants, and that the plaintiff has no legally recognized right whatsoever to maintain an action against the first defendant as regards the internal management, control, and disciplinary decision and or policies of the Senate of the National Assembly. The plaintiff cannot meddle into the internal affairs of the Senate. The plaintiff, in response to the second issue, contended that the totality of the submissions of the first defendant on this point is that the plaintiff lacks the locus standi to institute this action, since section 68(1) of the Constitution can only be activated by the second defendant or any member of the Senate by producing evidence satisfactory to the House Senate that any provision of section 68(1) in this case has become applicable, and that the plaintiff has demonstrated his locus standi in paragraphs 8 to 25 of the affidavit in support of its originating summons. That the plaintiff has the requisite locus standi to institute and maintain the present action in view of its rights, having sponsored the election of the first defendant and his resignation of its membership, and joining another political party enables the plaintiff the locus standi to institute this action. The third issue raised by the defendant counsel is whether, having regard to the peculiar facts and circumstances of this case, the plaintiff has disclosed any reasonable course of action for the Honorable Court to determine. On the third issue, the plaintiff, Delilah Silk, counsel to the first defendant, submitted that such an action will amount to an abuse of the process of court, frivolous, and which is meant to irritate, vex, and annoy the defendant. Counsel urged the court to resolve the second and third issues argued together in favor of the second defendant objector and strike out the plaintiff's suit in the interest of justice, as this honorable court lacks the jurisdiction to entertain same. The legal counsel to the plaintiff argued on the third issue that it discloses, that its processes discloses a reasonable course of action contrary to the unfounded submissions of the first defendant, whose argument that the plaintiff's originating summons discloses no course of action. This honorable court will determine issues 2 and 3 together as they are interwoven. The question as to whether the instance suit discloses any reasonable course of action to enable the plaintiff locus standi to institute same, the law is settled that in considering the issue of locus standi, it is the statement of claim or depositions in affidavit in support of originating summons that the court should look at. More often than not, for the reason of being interlaced or interwoven, the issue of locus standi is merged into course of action, although the two cannot be equated with the other. See Odumegwa and others versus Ibezim and others 2019 LPELR, UBN PLC versus Udesco, Line Nigeria Limited 2021 LPELR. It is settled that locus standi is the legal capacity of a plaintiff to institute proceedings in a court of law. It is also tried that for a person to have locus standi to sue, all he needs to do is to show that he has sufficient interest in the subject matter of the action, and that his civil rights and obligations have been or are in danger of being infringed. It is the statement of claim or affidavit in the case of action commenced by originating summons that will show whether the plaintiff has locus standi to sue or not. See Jite and another versus Apollo 2015 LPELR. Coming to the instant case, the plaintiff has demonstrated his locus standi in paragraphs 8 to 25 of the affidavit in support of his originating summons. In summary, the plaintiff is a political party that sponsored the election of the first defendant into the office of the senator representing Akwa Ibom Northeast Senatorial District, Uyo Senatorial District on 23rd November 2019. The first defendant, however, resigned his membership of the plaintiff and joined another political party, that is the Young Progressive Party, before the expiration of the period for which he was elected. The first defendant has also failed to vacate his seat at the Senate of the National Assembly. Consequently, the plaintiff who sponsored the election of the second defendant in accordance with Section 65(2)(b) of the 1999 Constitution, took out an originating summons for the purpose of enabling this honorable court to determine whether the first defendant is entitled to retain his seat in the Senate of the National Assembly in view of this Section 68(1)(d) of the 1999 Constitution. The question to ask from the above summary, can it be said that the plaintiff does not have the local standard to institute this action in view of its special right to sponsor the election of the first defendant and his designation of its membership and joining another political party? This honorable court answers this poser in the positive, in that the plaintiff has the requisite local standard to institute and maintain the present action. And I hold so accordingly, as it is settled that a plaintiff will have local standard only if he has special rights, or in the alternative, if he can show he has sufficient or special interest in the performance of duty sought to be enforced, or where his interest is adversely affected. See AMA versus Federal Republic of Nigeria, 2010 7 NWLR. It is instructive to note that a cause of action and standing to sue are linked to the issue of jurisdiction of a court. If the plaintiff does not have a cause of action or the standing to sue, the court cannot properly assume jurisdiction to entertain the matter. See Odumegwa and others versus Ebezim and others, Supra. This honorable court, having determined that the plaintiff has both reasonable cause of action and local standard to institute this action, thereby this court can properly assume jurisdiction to hear and determine the plaintiff's suit. I so hold. On the contention of the first defendant counsel, who argued, albeit erroneously, that it is only one of the persons listed in Section 68(2) of the Constitution, that is the second defendant, that can give effect the provision of Section 68(1)(g), which the plaintiff seeks to enforce. Also, that it is only the second defendant or any member of the Senate that can present satisfactory evidence to the Senate that the provision of Section 68(1) of the Constitution has become applicable to the first defendant. These arguments are totally misconceived, as there's nothing in the provisions of Sections 68(2) of the Constitution that expressly provides that it is only the person stated in the reference section that can give effect to the provision of Section 68(1), including 68(1)(g). I hold so. I am fortified in this line of reasoning by the holding of the appellate court in INEC versus DPP and another, 2015 LPLR 24900, Court of Appeal, that recourse can be had to a court of competent jurisdiction without the second defendant or speaker of a House of Assembly, as may be applicable, first giving effect to the provision of Section 68(1)(g) of the Constitution. Also, the Court of Appeal has held in the same case that a decision of this court shall constitute satisfactory evidence to the House for the purpose of the second defendant giving effect to the provision of Section 68(2) of the Constitution. Consequently, this honorable court holds that the plaintiff has both shown reasonable cause and has demonstrated local standard to institute the present action in its affidavit in support of the originating process. Going on to the fourth issue, in the notice of preliminary objection being whether, having regard to the peculiar facts and circumstances of this case, this honorable court has the requisite jurisdiction to grant the relief sought by the plaintiff, since same will either inure to the benefit of or against a non-party to the suit. Learners SAN's counsel to the first defendant answered the poser in the negative and submitted that it is a well-settled law and practice that a court cannot give a judgment against a person who will be affected by its decision if such a person is not made a person who will be affected by its decision if such person is not a party or has no opportunity of defending the suit. When made with order against a person who is not a party to a pending suit is to no avail. And that the plaintiff in its relief 5 sought from the court against the Senate or National Assembly, but never gave the National Assembly the opportunity of confronting the said adversary, whom the plaintiff wants the first defendant to return his entitlements and emoluments to. Learned counsel submitted that the plaintiff cannot expect to get judgment from the court when its adversary, whom it wants to give effect to the purported breach of Section 68 sub 1G of the Constitution of the Federal Republic of Nigeria, was not given a right to be heard. Therefore, the plaintiff's claim must crumble like a pack of cards, and counsel urged the court to hold and strike out or dismiss the plaintiff's claim for being incompetent, as the state's reliefs inure either in favor or against a non-party. Counsel urged the court to resolve the issue in favor of the first defendant's objector and strike out the plaintiff's suit in its entirety and in the interest of justice. As the condition precedent for the court to exercise its jurisdiction on same have not been complied with by the plaintiff. The plaintiff's counsel, on the other hand, submitted on the fourth issue that the meat of the first defendant argument on this point is, I need not repeat that. Learned counsel submitted that the determination of whether a party is a necessary party, and if non-joinder of such party will initiate an action, has certain determining factors as laid down by the questions that a court must ask itself in determining the questions that a court must ask itself in determining whether the non-joinder of the Senate of the National Assembly is fatal, as alleged by the first defendant. 1, is the cause or matter liable to be defeated by a non-joinder? 2, is it possible to adjudicate on the cause or matter unless the third defendant is added as a defendant? 3, is the third defendant a person who should have been joined in the first instance? 4, is the third party a person whose presence before the court as a defendant will be necessary in order to enable the court to eventually and completely adjudicate or settle all the issues, to settle all the questions involved in the cause or matter? Plaintiff counsel submitted that in respect of the questions above, that the essence of the present action is to give effect to the provisions of Section 68(1)(d) of the 1999 Constitution. And that the argument by the first defendant, the failure to add the Senate of the National Assembly amounts to a denial of the right of fair hearing is inapplicable. That in the entire case of the plaintiff, there's no allegation made against the Senate of the National Assembly in respect of which it will require to be heard. This is the conclusion reached in INEC versus DPP and another on similar facts, where the same arguments were made, and that for the avoidance of doubt, the Court of Appeals held thus: the issue of lack of fair hearing will not arise since allegations have been made requiring the Speaker or the House of Assembly to be heard. Counsel urges the court to discountenance the arguments and case law relied on by the first defendant contained in paragraph 6.1 to 6.9 of its written address and resolve issue 4 against the first defendant and in favor of the plaintiff. Now, this honorable court, in resolving issue 4, the law strides that the non-joinder of a party is not fatal and will not nullify an action, and the court may determine the issues or questions in dispute so far as they affect the rights and interests of the persons who are parties to the suit. See Green versus Green, 1987, LPER, Partico Difo Acuna Oputa JSC, as he then was, Ayorinde versus Oni 2000, 2 SCNJ, Machidi Nuama 1, JCA, and Umar versus Paris, and another 2021 LPELR. While first defendant contains that the Senate of the National Assembly is a necessary party whose presence is essential for the effectual and complete determination of the issues before the court, since the plaintiff wants to give effect to the purported breach of section 68 sub 1G of the Constitution. Consequently, the claims of the plaintiff cannot be effectually and completely determined in his absence. This contention of the first defendant counsel is not correct, because by the plaintiff's claims in his processes is that the essence of the present action is to give effect to the provision of section 68(1)G of the 1999 Constitution. By reason of the decision in INEC versus DPP and another supra, it is not a condition for the persons listed in section 68 sub 2 of the 1999 Constitution or the Senate of the National Assembly should be made parties to determine whether the seat occupied by the first defendant has become vacant. The Court of Appeal in INEC versus DPP and another considered this point in relation to section 109 sub 1 and 2 of the Constitution, which is in pari materia with section 68 1 and 2 of the Constitution. The relevant portion of the dictum is reproduced. I've read the dictum earlier. Consequently, this honorable court is more inclined let me read out the dictum. There's nothing in section 109 of the Constitution which stipulates that the Speaker of the House of Assembly or the House of Assembly itself must be made a party in an action to determine if the seat of a member of the House of Assembly has become vacant. In fact, the court held categorically that it is not necessary to make the Speaker of the House of Assembly or the House of Assembly itself a party in an action to determine if the seat of a member of the House of Assembly has become vacant. In effect, it is not even necessary for the plaintiff to make the second defendant a party in the action. As such, the non-joinder of the Senate of the National Assembly is not fatal to the action I so hold. Also, the argument by the first defendant that failure to add the Senate of the National Assembly amounts to a denial of the right of fair hearing is inapplicable. in the entire case of the plaintiff, there's no allegation made against the Senate of the National Assembly in respect of which it will require to be heard. This is the conclusion reached in INEC versus DPP and another Supra on similar facts where the same arguments were made. For the avoidance of doubt, the Court of Appeal held that the issue of lack of fair hearing will not arise since no allegations have been made requiring the Speaker or the House of Assembly to be heard. Consequently, this Honorable Court is more inclined to be persuaded with the contention of the Plaintiff Counsel that the first defendant cannot cry more than the bereaved. The first defendant does not hold the brief of the Senate of the National Assembly, and as such cannot, by arguing, allege potential or actual violation of the right of a non-party. Now, having resolved the preliminary issues, the preliminary issues in the NPO, the second defendant, I'll go on to the second defendant who has filed a 6-paragraph counter affidavit deposed to by Toby Olaya and a written address in their argument against the originating summons in urging this court to strike out the suit. Counsel distilled 2 issues for determination. One, whether from the state of the affidavit in support of the plaintiff's originating summons, this suit discloses any reasonable cause of action against the second defendant. 2, whether having regard to the state of the affidavit's evidence in support of the plaintiff's originating summons, the plaintiff has made out a prima facie case to be entitled to the relief sought. Now, counsel submitted on issue 1, whether counsel answered in the negative, the issue being whether from the state of the affidavit in support of the plaintiff's originating summons, this suit discloses any reasonable cause of action against the second defendant. Counsel answered in the negative, that this suit is bereft of any cause of action against the second defendant. On the second issue, whether having regard to the state of the affidavit evidence in support of the plaintiff's originating summons, the plaintiff has made out a prima facie case to be entitled to the relief sought. Counsel submitted that the burden of proof in a civil case such as this falls on the plaintiff, who alleges the existence of certain facts. Therefore, for his suit to succeed, he must adduce cogent and credible evidence in proof of the facts he alleges. The plaintiff counsel, in his reply submissions to the counter affidavit of the second defendant, submitted that the originating summons discloses a reasonable course of action. In resolving this issue, this honorable court, having perused processes from both parties, observed that the second defendant made those submissions with judicial authorities on meaning and determination of a course of action, but failed to avert his attention to the peculiarities of the present action. In the instant action or case, the grounds of the plaintiff is based on the acts of the first defendant, who was sponsored by the plaintiff and elected to the office of the senator representing Akwa Ibom Northeast Senatorial District, otherwise known as Uyo Senatorial District, resigning his membership of the plaintiff and defecting to another party whilst retaining the office to which he was elected, the platform of the plaintiff. And the consequences of the action of first defendant, as evidenced by the reliefs of the originating summons and facts deposed in the supporting affidavit, is that by the provisions of section 65 sub 2b and 681g of the 1999 Constitution, the first defendant who has resigned his membership of the sponsoring party, that is the plaintiff, and defected to another party, cannot continue to retain his seat in the Senate. This honorable court, having considered the originating summons and the supporting affidavit, the questions formulated and relief sought in the originating summons and paragraphs 1 to 25 of the plaintiff supporting affidavit has determined that the plaintiff processes discloses a reasonable course of action. See Ajuwon versus Governor of Oyo State, 2021, 16 NWLR. This honorable court, having resolved that the plaintiff's affidavit have disclosed reasonable course of action against the second defendant, I'll go on to determine whether the plaintiff has made a prima facie case against the second defendant and therefore is entitled to the relief sought. The provision of section 68 sub 2 of the 1999 Constitution is reproduced below for ease of reference. The President of the Senate or the Speaker of the House of Representatives, as the case may be, shall give effect to the provisions of subsection 1 of this section. So, however, that the President of the Senate or being the Speaker of the House of Representatives or member shall first present evidence satisfactory to the House concerned that any of the provisions of that subsection has become applicable in respect of that member. Being that the above reference provision of the 1999 Constitution vests the second defendant with the power to declare the seat of a member of the Senate vacant, the apparent failure of the second defendant to do so upon notice of the ground to do so raises a question as to the application and enforcement of section 68 sub 1G of the 1999 Constitution. This honorable court holds that the second defendant is a proper party in the present action given his constitutional position as the president of the Senate, and it is desirable for the second defendant to be bound by the decision of this honorable court. See Green versus Green. The submissions of the second defendant on this point is hereby discountenanced in its entirety as the plaintiff has a reasonable course of action against the defendants, especially the second defendant, and has demonstrated it in its originating summons and the supportive affidavit. Being that the above reference provision of the 1999 Constitution vests the second defendant with the above power to declare the seat of a member of a Senate vacant, the apparent failure of the second defendant to do so upon notice of the ground to do so raises a question as to the application and enforcement. Okay, I think I've resolved that issue. In the final analysis, this honorable court holds that the plaintiff has successfully proved his case on the preponderance of evidence. Consequently, 1, this honorable court hereby declare that by virtue of section 65(2)(b) of the Constitution of the Federal Republic of Nigeria, 1999, the first defendant being a person whose election on 23rd February 2019 to the office of senator representing Akwa Ibom Northeast Senatorial District, otherwise known as Uyo Senatorial District, was sponsored by the plaintiff, is no longer qualified to retain his seat in the Senate, having resigned his membership of the plaintiff.
As the court pleases.
2, this honorable court hereby declare that by virtue of section 68 sub 1G of the Constitution of the Federal Republic of Nigeria, 1999, the first defendant being a person whose election on 23rd February 2019 to the office of senator representing Akwa Ibom Northeast Senatorial District, otherwise known as Uyo Senatorial District, was sponsored by the plaintiff, is liable to vacate his seat in the Senate, having resigned his membership of the plaintiff and become a member of the Young Progressive Party before the expiration of the period for which he was elected. 3, this honorable court hereby declared that the seat of the senator representing Akwa Ibom Northeast Senatorial District, otherwise known as Uyo Senatorial District, in the Senate has become vacant.
As the
Four,
court pleases.
this honorable court hereby order that the third defendant shall conduct a by-election to fill the vacant seat of the senator representing Akwa Ibom Northeast Senatorial District, otherwise known as Uyo Senatorial District, in the Senate for the unexpired term of the first defendant, not later than 14 days after the order of this honorable court.
As the court pleases.
5, this honorable court hereby order that the first defendant shall refund to the Senate of the National Assembly all monies, allowances, or other financial and material benefits paid, given, or yielded to him after July 15, 2022.
As the court
6,
pleases.
this honorable court hereby grant an order of injunction restraining the first defendant from claiming to be or parading himself as a senator representing Akwa Ibom Northeast Senatorial District, otherwise known as Uyo Senatorial District in the Senate.
As the court pleases.
7, the first defendant is to pay 5 million naira as cost of the suit. Judgment given in favor of the plaintiff.
As the court pleases. On behalf of the second defendant, we appreciate your lordship for the well-considered judgment. Thank you, my lord.
Thank you, counsel.
May I please, my lord? We want to appreciate your lordship for the
Thank you so much, counsel.
My lord,
Having come to the end. Yes,
I said, we thank my lord for the industry.
thank you,
My lord.
Leonard Silk. Having come to the end of today's proceedings. Thank you, counsel.
I didn't know it.